So good afternoon, everyone. Thank you for tuning into our webinar, Funding Construction Projects, Loans, Assessments, and Reserve Spending. We have muted all the participant devices to eliminate the background noise so everyone can hear clearly. So Jeff, if you would do me a favor and go to that first slide that kind of explains the Q&A option so that our guests have some idea as to how to navigate that. As you can see on the screen, you can submit questions at any time by navigating to the Q&A option on the toolbar, and instructions on how to submit a question are being displayed on the screen. Oh, I'm sorry, that's, yeah, it's the next slide, Yeah, that's how to submit a question, great. And then to change your view options, that would be the slide before, Jeff. And what you can do here is just adjust the display so that you can see all the panelists by navigating to the view options on the toolbar and then select the side-by-side option for the optimal view. Great. So I'm now going to turn it over to today's presenter, Michael Bender, partner at the law offices of K. Bender Rembaum. Michael and several of his attorneys are board certified specialists in condo and planned development law and have offices throughout the state servicing condos and HOAs. They are a great firm, and I personally can attest to Michael's expertise and contribution to the community association world at large. I've personally witnessed that. He's absolutely great. So I'm very excited for this class today and to learn more about this subject matter. So without further ado, thank you again for joining us, and I will turn it over to you, Michael. Go ahead.
Thanks, Jess. Good afternoon. Great to see you. Welcome, everybody. Again, Mike Bender with K. Bender Rembaum. And what we're going to do today is we're going to be talking for the next 45, 50, maybe 60 minutes or so about the funding projects, primarily construction projects. And as the title suggests, there are basically three different ways. There's the loans, there's assessments, and there's reserve spending. And we'll spend a little bit of time on budgets and assessments, as well as reserves. And then we'll spend a larger portion of time on the loans and the financing aspect of it. I do want to point out that I'm happy to be here. It's happy seeing some of you, if you're first timers, or those of you, I'm not seeing you, but I appreciate you being there. I am not giving legal advice today, though. I'm here providing information. I'm here hopefully provoking some thought. And certainly indicate, giving you some answers to some questions, but I don't want you to accept this as legal guidance. If you don't have experienced counsel, you should look for experienced counsel. If you have counsel you're working with, you should be following up with your counsel if you have questions. When you're talking about construction projects, the funding, in fact, the whole process of them, you should be actively working with your business advisors and your financial advisors and your legal advisors on making sure you're best protecting the association. So with that, I will very briefly talk. The first couple of slides just kind of touch upon. We're talking about large expenditures, and large obviously is relative to your community. So I'm not going to suggest a dollar amount here, but some of the examples of large expenditures are listed there, and certainly that the first item is self-explanatory, and the second item has become obviously a lot more front page news, if you will. Due to the recent tragedy that we had here in our neighborhood here at Surfside, our local area. So concrete restoration, fire life safety code upgrades, any sort of components, upgrading building components, elevators, seawalls. If you're doing pools, sometimes you have, some communities have condos in particular, cooling towers. These are certainly some of your larger expenditures. Even painting of the buildings. I've reviewed contracts where painting of the buildings are high six figures. So, and then there might be some, but for some communities, some smaller communities, a $50,000, $100,000 project can be considered a large expenditure. So like I said, it's relative, but I want you to just keep, the reason I bring that up in the beginning is I want you guys to have your minds kind of in the mindset of where I'm at what I'm talking about here. So let's go to the next slide. We'll talk about sources of funds generally, annual budget and special assessments, reserves, and financing. And so what we'll do is, and what we're going to talk about, and that sort of breaks the program up. I'm going to first talk about budget and reserves. Okay. So, budget and reserves. All of you, hopefully those of you, your board members, maybe your property managers, you're all aware that the association's function with an operating budget. And then some communities have funded reserves. I'm going to speak, I'm going to the best, as best I can, I'm going to separate the condominium and the HOA with regard to the reserves portion, because they are certainly treated differently under current Florida statutes. And when I talk about Chapter 718, that's your Condominium Act. Chapter 720 is your HOA Act. So if you hear me use 718 or 720, that's the term, that's what I'm referencing to. 718 being condominium, 720 being HOA. So before I get into the slide and the reserves, I want to talk about, obviously you have operating budgets. All board members are adopting operating budgets, whether you're in the condo or the HOA. The operating budget is exactly what it sounds like. It's to address operating expenses, and it's supposed to be a budget that's adopted, toward the end of the fiscal year, the prior fiscal year, for the next fiscal year. Most communities do that January, calendar year. So for purposes of discussion, say November, October, November time, and certainly hopefully no later than beginning of December, you've adopted a budget for your operating expenses for the following year that have line items that address all of those expenses you anticipate on an ongoing basis, or perhaps it's an item that you have a one-off. It's not going to be a recurring, but you have expenses coming up next year, so you add a line item for that. That's good for the condominium and the HOA. So the second part of the budget is the reserves, and this isn't a course on budgeting and reserves, so I'm not going to get into depth of that. However, will talk about certain parts of the certain points, legal issues that come up with reserves. And so you do have the second part is the reserves. And in the condominium under 718, the statute mandates that the boards fully fund reserves. And reserves are specified in 718 as being for paving, painting, roof, paving, painting, and any deferred maintenance item in excess of $10,000, which if you remember the earlier slide where I talked about some of those building components, the elevators, the seawalls, things, that cooling tower, those are all going to be considered into the deferred maintenance because they're going to exceed $10,000. So those are your specific items in Condominium Act. In the HOA, they don't spell them out as specifically, and I'll talk about HOAs in a second because their reserves are very different. But in the condominium world, it's very statutorily created and dictated. So you have a budget that you adopt with fully funded reserves. How do you know how to fully fund the reserves? Well, that's the first item. The first bullet point there talks about reserve studies. And I can, again, that's obviously, I'm sure that anybody who's read the newspaper since the end of June, I think it was June 24th when the Champlain tragedy occurred. There's been a lot of talk about the question of waiving reserves, and I'm going to talk about that a little further. But the idea of how do you ascertain what your reserves should be, so that you know what you should be considering in a fully funded reserves budget. And while there are other ways to go about it, you could go about and get proposals, for example, for the roof. And based on those proposals, you can have an idea of what the roof is going to cost to replace. However, the challenge you have there is that the proposals you're getting are for today. If you're not replacing that roof for 20 years, it's not necessarily going to be accurate. Reserve studies, and there are professional companies out there that do reserve studies. Reserve study would be my recommendation for how what a board should be doing to ascertain the replacement value of the items that should be in the reserves, which as I earlier mentioned, again, condominium, roof, paving, painting, and any deferred maintenance item over $10,000. What that entails for your community, and this is why this can't be a uniform thing, because communities are different. There's going to be certain communities that have a list of 20 different items that should be in the reserves, others that may just have 3, 4, or 5. So in that regard, I would encourage you to, as a board, to consider having, if you haven't had a reserve study done in the last 3 years, to consider getting proposals from these reserve study companies and commissioning one to do a reserve study for you. I would further suggest that a reserve study should be done no less than once every 5 years. There was language in the statute about 10, 12 years ago that required that, which only lasted in the statute for 2 years. But I would recommend, that's my recommendation. Again, it's up to you, and you can certainly speak with your business advisors and your own legal counsel that to get their feedback. But I would suggest you get a reserve study. The reserve study is going to tell you what items should be in the reserve study, or at least it should tell you what items should be in the reserve study, and how you calculate your reserve funding. In generally speaking, the way you calculate reserve funding, let's use a roof, for example. Say a roof is, and I'm going to use very simple numbers. A roof is has a 20-year lifespan, and it's going to cost $20,000 to replace. You would then need to, and if it's year zero, you would need to reserve $1,000 a year, because at that rate, at the end of 20 years, when the roof needs replacing, you'd have $20,000 in your reserves. So now, if you were already at year 10, and you just said, "Oh, we've been waiving reserves," which I'll talk about in a minute, waiving reserves for the last 10 years. Now we have zero in our roof reserves. It's a $20,000 roof replacement, and we only have 10 years left on this roof. You're going to then want to, your reserve in your budget would show $2,000 should be reserved for each year for the next 10 years. That's very rudimentary math and very generically how you determine the reserve funding portion of your budget. And so that you can ascertain how much, on top of the operating expenses, how much money you should be budgeting for each year. And then, of course, when you collect those funds, the funds that go to operating should be in the operating, and the funds that are to apply toward reserves should, but while they can be commingled in the bank, they should be clearly delineated on the paperwork, showing that you have money in reserve. In fact, you should have you might even be smarter to actually have a separate account for your reserves, your reserve funding would be my recommendation. And certainly your accountants and your business advisors can give you more advice on that. One of the big challenges that has come forth as of since June, the end of June, has been the number of communities that have waived reserves. The statute provides in the Condominium Act that you must fully fund reserves. So if a board wants to fully fund reserves, it's completely within that board's discretion. However, meaning no vote of the membership is needed. However, if the board wants to do something less than fully fund, which is either partial funding or actually waiving reserves for the year, then a vote of the membership is necessary. The vote that's needed is not a significantly high number either. You establish quorum, and depending on your governing documents, in the condominium world, your quorum requirement is going to be a majority unless you have a lower number in your documents. Several condominiums we represent only require a third. So you need to establish quorum, and then a majority of the quorum is what is needed to approve either waiving or partially funding reserves. And what I've seen, and I think what many have seen, is communities who have considered kicking the can down the road, or just saying, hey, listen, we don't want to, we reserves, if we fund our reserves, it's going to significantly increase the budget. And that's not something we want to be looking to do right now. So I think there has to be some kind of happy medium. You have to obviously be planning properly. And I can tell you, I know that there's already been talk up in Tallahassee about trying to address reduce or restrict the ability to fully waive reserves. I don't know that that's going to go anywhere, but it's obviously talk. There's reactions and there's overreactions. I'm not suggesting this is an overreaction, but there's certainly reactions going on, and because of the information that came out about the inability for Champlain to have, they had $15 million worth of repairs that were needed, and they had very little in reserves to cover that, or certainly a small percentage. And that's quite frankly something that we've seen in a lot of communities, some that we represent and a lot that we don't represent. When we are doing our classes and stuff and people talk about this, it's not an uncommon thing. I can say that over the last few years, certainly even prior certainly to this year, I have seen more and more communities that had waived reserves in the past decide that's not working for them for the long term, and I applaud that thinking. And they've moved toward at least some partial funding. So that's and increasing that partial funding. Again, if you want to do anything other than fully fund, you must go out to the membership and get a vote. The vote is only good for the year in which you are seeking to waive. So if you're going to look to adopt a budget for 2022, and you want to waive or partially fund reserves, I recommend that vote should be taken by the end of this year, and it only applies for 2022. If you wanted to do it again in 2023, you'd have to do another vote. Okay. Let me see. Okay. With regard to HOA, by the way, HOAs are different in that the statute doesn't require 720 doesn't mandate reserves the way 718 does. 720, with the change in the law, recent change as of July 1st, basically 720, you're only going to have statutory reserves if they're set forth in the governing documents, or if the membership votes to approve them, which in my life, I've never seen. In my 20 plus years of doing this, I've never seen membership vote to add reserves. Maybe that'll be different now. I don't know. But anyway, so the 720 is it's more likely that the board has discretion there to set funds aside for reserves, to approve an additional line item, if you will, in the HOA budget that accounts for reserve funding for different items. And again, a reserve study for an HOA is certainly recommended as well. There's probably less items that you'll have in an HOA, depending on the makeup of the HOA, that need reserving, but there'll be items that you might want to consider reserving for future, depending on what the HOA is responsible for. Talk to your accountants as well. If you're not funding reserves, there are some disclosure requirements that are necessary in your financial reports. Your CPAs will be familiar with that. Okay, pooled versus straight line reserves. Again, very briefly, the straight line is what I'm talking about, and that is where you have a line item for roof, a line item for paving, a line item for painting, and then maybe a line item for a cooling tower, a line item for elevators, etc. And you would reserve funds into those items. And any fund, so when you, like the example I gave, if you put $1,000 into the roof fund, and then 5 years in, you have $5,000 in there, and you realize that the roof isn't likely to need replacing for 15 years, but you suddenly have a need to address the paving, and you don't have enough funds in the paving reserve line. In order for you to take funds from the roof reserve line in straight line reserves, you must get a vote of the membership. The same vote you need to waive or partially fund is the vote you'd need to take reserves out of a straight line item and use it for a purpose other than for which it's been designated. So the reserve funds have been designated to the roof. In your budget, you said we're taking $1,000 this year, putting it in the roof reserve. Well, if you know those, once it's in there, it's in a roof. If you want to use that for some other purpose, you need the membership to approve that. And I can tell you that I've had more than a few communities who have come to us, who have had come to us because they've had issues, complaints filed against them, and the DBPR is investigating, and they've retained us and asked us what's going on, and we've essentially informed them and educated them. You can't borrow money from your reserves without a vote of the membership. And I don't recommend that you do so, even if you're going to put it back before the end of the year, because if owners get wind of it and they file a complaint, my experience is the division will cite the association for a violation. So just keep that in mind. If you have money in reserves and you want to use it, so you don't have to levy a special assessment, if you don't have to go and take a loan, depending on the dollar amount, you can borrow from the reserves with the approval of the membership, okay? A majority of the quorum. I can't emphasize enough, communicate with your experienced association counsel and get guidance, and in fact, let them help you prepare the notice package, and so you have documentation, proper documentation to support what you're doing. It's money well spent. Pooled reserves, and I've seen more communities do that. Pooled reserves are essentially taking all those lines, the roof, the paving, the painting, the elevator, etc., and throwing them all together into one pool. So and that's where it's in fact, in order to do pooled reserves, I'd say you can't do pooled reserves, in my opinion, without a proper reserve study. Because if you could, the reserve study will go out 30 years and it'll tell you each year how much money you should be putting into that pool to ensure that whenever these different pooled reserves items come up, the funds are going to be available. One of the advantages to pooled reserves is, in my example, if you had a pooled reserve account and you were throwing money in for the roof according to the reserve study, and a certain amount of dollars for the roof and a certain amount of dollars for the painting, and suddenly you realize, we had a need to paint much sooner than we thought, because the funds are pooled, you can use those funds, the funds that are in there, for any of the purposes for which that pool has been designated. So it's not a line item designation where you need a vote of the membership. The board would have the authority and the discretion to use the funds within the pool reserves for any of the items for which that are in the pool. Okay, so I hope that's clear. Okay, let's move on to special assessments. Let me just see, before I do that, let me check and see if there's any questions on reserves.
Yeah, I saw some here that are
yeah.
relevant. That maybe
Ms. Fidelvis, if you don't have reserves, I think I addressed that. I think I addressed what my recommendation is. And I will just add this. With regard to if you don't have reserves, I've mentioned some of my communities are, if you go from no reserves or having waived reserves year after year to fully funding, that's going to be a pretty big hit to the community. Well, one thing I'll emphasize, and I emphasize this all the time, open lines of communication between the board and its membership at all times. With information is imperative. This type of information, talking about where funding is going, where funding is needed, and what you plan on doing in advance of when you do it. So, again, I point out to all of you who are not board members, it's self-explanatory. Board members are owners as well. When they're putting in an increasing maintenance, or they have to adopt a special assessment, it's not at you, it's at collectively all of you. They have to pay the same things that you do. And so they're, looking to be fiscally responsible, but also they have a fiduciary duty to protect the association, the corporation, the condominium, or the HOA and its elements. And so, that is important to keep that in mind. But you can maybe gradually start increasing reserves. Maybe if you've never had reserves and you need reserves, maybe the first year you implement some smaller percentage, 25% of what you would need, a partial funding at 25%, and then slowly build up from there each year. And that's one suggestion. David Humphrey asked about how thorough is the engineering reporting for the reserve study? Should we not get a separate in-depth engineering study and loop that into reserve study? I think, David, that is a very sound idea. There has been, I'm not the reserve study expert. I would recommend, if you're getting reserve study proposals, that these are the great questions, David. That's a great question that you be asking. And obviously, you have Castle, you have really solid business advisors. Or if you're working with someone else, make sure that they're qualified business advisors and they can assist you in that regard. And certainly, if you've been working with engineers on your property on other projects, you can get their opinions as well. But yes, I want to make sure these reserve studies, are in depth enough that they're addressing the needs, in light of what we've, learned better learned. And so we can take lessons, in going forward. Caroline asks, if reserves are set up by a previous board, do you still need a vote of the membership to move reserves to something else? Okay, I'm going to listen, unless you say in the question, you're an HOA, I'm going to presume you're a condo. And I'm going to assume, Caroline, you're talking about a condo. And if reserves, remember, when you say reserves are set up by a previous board, I don't know, what that means. If you're a condominium, obviously reserves are set up by statute. So Caroline, if you want to let us know if you're an HOA, but in a condo, obviously the reserves are created by statute. Now, if that means the board if in a condominium, the board said, we're not going to waive reserves, we're going to just approve reserves, fully fund reserves, then.
She's in an HOA. She's in an HOA.
Okay, thanks. Again, I'll answer both. If you're in a condo, any reserves that have been established are statutorily protected. And yes, you would need a vote of the membership to use the money for something else. In an HOA, and using the way you wrote it, Caroline, another good question. If reserves are set up by a board, okay, and this is something we talk about all the time. If they're set up by a board, those are not really called reserves. And I would hesitate that you label them as reserves, because that indicates something that's controlled perhaps by statute. To me, those are really it's more discretionary in that regard. If the board has quote unquote set up a reserve line item, then those are more discretionary, and the board could decide to use those funds for another proper purpose. If they're not governed by the statute, they're not statutory reserves, then they're not limited by the requirements of the statute, meaning a vote of the membership to use those, to waive them, or to partially fund them under condo, or to use them for a different purpose. And so yes, the answer to your question, Caroline, you would not need a vote if it's board created reserves, quote unquote, because they're not really statutory reserves. To change from line item to pooled reserves, The board would have, James, the board would have the authority. If, let's just say in 2022, the board says we want to now going forward use pooled reserves, starting with the funds we collect in 2022, that's a board decision. However, if there are prior reserve funds that you have in line items and you want to convert to a pool, throw them all into the pool, well, then you need the vote. Because what you basically, if you think about it, what you're doing is you have a line item for roof, paving, painting. You're now throwing them all into a pool, which means the funds you had in the roof, you may now use for something else. So in order to approve that, you would need that majority of the quorum vote. Okay, I am going to move forward and then I'll come back. Mary, by the way, I do believe that this is being recorded and there'll be links to this program on both Castle and KBR's websites. Mary, okay. And if I didn't hit your questions, I will try to get to as many as I can at the end. I just want to make sure I get through the materials. Special assessments. And Ralph, I didn't ignore you at the top there. I just am special assessments is what I'm going to talk about now. And I will talk about them now briefly, and then I will, obviously, they'll be part of the discussion on financing. Special assessments is another way of funding. And obviously special assessments come into play when you don't have sufficient funds in operating surplus, or you don't have sufficient reserves or other funds set aside to do these projects. And really what I want to just mention with special assessments is it's very much dictated by statute under 718 and 720. And so I want you to be aware and really, don't shy away again from using experienced legal counsel and management team. I implore you as well to, if you want to prepare the notices, then recommend to the board, I'm going to prepare them, send them to your counsel for approval, or say, hey guys, let's have your counsel prepare these notice documents to ensure we have what's required by statute. So you don't have challenges later that the process was incomplete or done improperly, especially if some owners don't pay the special assessments and you want to look to collect against them like you would any other assessment with the lien process. I can't tell you, we have had files sent over to us, and if the special assessment hasn't been properly approved, you've got to go back in time and correct it, and just delays the process. So better to get it all done up front. This contents and timing of the notice. This notice of the special assessment should be very clear that it is a special assessment is being considered. The purpose of the special assessment should be included in the notice, as well as a reasonable estimate of the amount of the special assessment. It does not need to be an exact dollar amount, but it should be, a reasonable estimate. And a minimum of 14 days notice needs to be, that notice needs to be posted in the community or in the condominium buildings and mailed to all owners at least 14 days prior to the meeting. I say at least 14 days because it's important to check your governing documents. Some governing documents require a 30-day notice. I've seen one, I saw 45, but that's very, very unlikely. But I have seen 30-day notices. So if you want to adopt this, most you can get to 14 days, but there's a few that have 30. And if you haven't checked that or had gone to your counsel and confirmed that, then you end up having a potentially defective. Well, you have a defective notice with a potential legal challenge to it. So make sure it's done right. When a limitation in governing documents, what that refers to is some of you may have language in your documents which says that the board cannot adopt a special assessment of a certain dollar amount, dollar threshold, without approval of a certain percentage of the members. Whether you have to follow that requirement will depend on the purpose of the special assessment. And speaking in generally, if the project for which you're doing the special assessment addresses necessary repairs or maintenance versus a material alteration or a capital improvement, if it's that necessary maintenance or repairs, then there is law that supports, and it's case law, it's not statutory, it's case law that's been in place for decades, that supports that the board not only has the right, but an obligation to undertake these repairs. And if you were handcuffed by a community telling you, nope, we don't want to spend the money, well, then you're gonna then when you don't do the repairs, and then there's an issue, and let's not suggest that it's just, a horrible tragedy like that, but even other damages to the person or property, they're going to come after you and say, wait a minute, why didn't you fix these things? Well, fortunately, there was a court, I think it was in the late 70s, in fact, who a smart judge recognized this and said, listen, I understand the document. I'm paraphrasing greatly, but I understand the documents. require a vote of the membership for a special assessment. But if the board does not build that seawall, the condo is going to fall into the water. And if the membership has to approve the $800,000 and they won't, and the board doesn't build it and the condo slides into the water, who do you think the owners are going to be screaming at then? So the judge basically said, well, even, and in this case, by the way, that building of that wall would be a capital improvement. Clearly, there's no wall there. They're going to add a wall. So that would be a capital improvement. But what the court said was not only it's a capital improvement, but it is in the nature of being necessary maintenance, necessary repairs and maintenance, because without building a wall there, you're losing the land and you're sliding in. And this court said the board does not only has the right to build that wall and charge the owners for it, but an obligation to do so. And that premise has been carried forward in condos and HOAs ever since. I stand behind that. I'm not giving you legal advice, but I do stand behind that. And I think that any community association lawyer who's got experience in this field will agree. And so a great example is if you were passing a special assessment to replace your roof. Well, replacing your roof would be necessary maintenance and repair. So you would have that authority, even if your documents required a membership vote for a special assessment. However, and I'm going to make this again, simple. Say you have a shingle roof and you want to switch it to a barrel tile. Well, the shingles to the barrel tile would be a material alteration. So while the roof replacement's maintenance, the change in materials could make it a material alteration, which might require the vote. And that's going to depend on the language of your documents. I've seen documents that only require a vote if the cost of the alteration will exceed a certain dollar amount. So if you have a building that is white and you want to paint that building blue, white to blue, according to the division, is a material alteration. It changes the appearance. But if the cost of painting it white is the same as the cost of painting it blue, and your documents have language that only needs a vote if there's an expense to the change, you may not need a vote in that. It's important that you get with counsel. Don't rely on your managers either. It's not fair to burden them with trying to give you that type of advice. They may have an opinion, but they obviously will defer you to your attorneys, and that's where you should pay to get a written opinion upon which the board can rely to make your fully informed business decision as to whether you need a vote or you do not need a vote. So that's what the limitation in governing documents refers to. Okay. With regard to what percentage of unit owners, Ralph, have to approve the special assessment, that is going to be dictated by your documents. That is not by statute. Okay. Okay. Let's talk about financing. Okay. How are we doing on time? Okay. We're going to talk about financing for about 20 minutes, I think, and then I'm going to try to answer as many more questions as I can. Okay. So we've talked about your budgets. We've talked about having funds available, whether they be operating surplus, whether they be reserves. We've talked about special assessments, doing straight up special assessments. The third, and what I want to focus now the rest on, is financing, is when you as a board will say, okay, we have these large construction projects that are going to cost significant dollars. And depending on the size of your community, like I said, 50 to 100,000 could be significant, but a lot of, I'm looking at loan packages now, anywhere from 2 to 15 million. So, so the numbers vary. And again, it will depend on the community and depends on what's going on, that you have to have done or over the next few years. And obviously these 40-year certifications are being really scrutinized even further. And boards are being more proactive, and I applaud that. So loans and credit lines, and basically what that I'm talking about, either or. Whether you go for a loan or whether you go for a credit line really is a business decision, and it really, in large part, it depends on the projects that you're undertaking, when you plan on undertaking these projects. Meaning, if you're doing a project that's going to start in a month and it's going to take 6 months and you're done. And you know what it's going to cost, you might decide to take the term loan. If you're doing something that might carry out over a little bit longer, you might look for the line of credit, which will allow you maybe 12, maybe 24 months of interest only payments. And then you're drawing, and because you might have funds in operating, you might have funds in reserves that you want to first use, but it's not enough. So you open up this line of credit. And because you're not 100% sure how much of it you're going to need, and you can borrow up to a certain dollar amount. You don't have to take all of that. And of course you want to go, as with any vendor, there are a lot of good banks out there, a lot of banks that are offering terms to community associations, some banks that do a lot more borrowing loans to community associations and are more familiar with the process. I've seen a couple of other banks that of late that I hadn't seen before into the market. I don't offer that that's, they're better or worse. I'm just saying there are options out there, and often you have your funds with a particular bank, and that certainly makes sense for that to be the first bank you go to and see what type of terms they're offering. Because with any loan that I've viewed, any bank that's going to lend you money, they want you to have banks accounts established at their lending institution. But I suggest that it's worth comparing, getting term sheets from get one from your current bank, but also go out and see the other banks are out there, and if it's better enough to have you consider switching, or going back to your current bank and saying, listen, we need you to do better. We've been with you for a while. We want to keep the relationship, but we need a better deal here. So it's negotiation. So, and whether it's a loan or a credit line, that's something that you can discuss. You can get with your management team, your business advisors, and certainly you can reach out to your counsel as far as the pros and cons once you have the terms in mind. The authority of the association to incur debt is what I next want to focus on. And this is where I want to be very clear. I talked a few minutes ago about having language in your governing documents which mandates a vote of the membership for a special assessment. And I pointed out to you that if it's for necessary maintenance, the law supports that you don't need a vote of the membership. You have the authority to go ahead and hit the levy assessments, whether, increase your budget or hit them with special assessments, and you don't need that vote. That is not, in my opinion, that is not the same. That the authority of the association to incur debt, I believe that if your governing documents do require the membership approval to borrow funds, in my experience, the banks are going to require the membership approval. And the banks also often require an opinion of counsel, your association counsel, to confirm that you have the authority to borrow, that you followed all the guidance, the requirements of your governing documents, of the Florida statutes, and of the loan documents. And therefore, simply put, if the governing documents require a vote of the membership to borrow funds, then you're going to need to get that vote before you can move forward with the loan facility, either the loan or line of credit. Now, as a practical matter, I offer this. If you say to the membership, oh, and by the way, what vote percentage would you need? Will depend on what the language of your documents say. Deck articles. Typically, this statute refers to, and this is chapter 617, your not-for-profit, refers to articles or bylaws, but in the rare instance it's in your declaration, I would say you need to follow it as well. But it's going to be whatever it says, a majority, 2/3. If it's over a certain dollar amount, it's going to be whatever it says. So as a practical matter, a board says, hey, Mike, do we need to get approval? I look, you do need approval. Well, we'll never get 2/3 of the owners to approve it. Okay, well, that may be so, but when you left 2/3 of the owners know, and you have you either need to do a special assessment of $5,000 a unit that you have to pay within 30 days because you have a project that has to be done now, or we can have an option where you can pay that $5,000 out over 12 months, 24 months, 36 months, whatever it is. So in order, though, to give you that option, we need you to approve the board's authority to borrow up to a certain amount. So when presented with, and by the way, that option, the way I propose that option would be, hey, for those of you who don't want to have to pay interest on your loan, you can lump sum. We can do a lump sum for you, and you don't have to pay the interest. But for those of you who want to carry it out, then you'll pay a little bit of interest, and you'll cover your portion of that interest. But if you don't approve this, if you don't give us the authority to borrow, we have no choice. We will then do a special assessment and we'll all have to pay much faster. That seems to be that usually is very effective. And it's not a threat. It's not, basically it is what it is. You have obligations, and hopefully it's not that significant. Hopefully you're able to plan in advance as much as possible so that you can have these monies collected over time. But sometimes it doesn't work that way. Emergencies come up, situations arise that you're not aware of, that you weren't planning on, and it happens. Or maybe new board comes in and things that weren't necessarily done previously that the way they should have been done, and new management team finds things. Who knows? So the authority of association incurred debt, though, what I'm going to talk to you about in a moment is, the Qualifications criteria and the board versus membership approvals, those I've talked about. I've talked about a little bit with the special assessment, and I will get into them again in a moment, but let's go to the next slide. Okay. The commitment letter is where the loan process starts. And I use the word commitment letter. That's often what I see. I have seen some banks do a term sheet. I recently had a situation where there was, according to both the bank and my client, there was no initial term sheet or commitment letter, which confuses me. How they just provided loan documents, and that's where we started. But I will say 99% of the 99.5% of the time, there is some kind of term sheet or letter of commitment letter from the bank for the board to review. I'm going to recommend to you, and this is the reason that we put this course together. In addition, obviously the other aspects are important, but when you're talking about borrowing, and that's really what I want to hammer home now. If you're going to borrow funds, in order to ensure the process is smoothest, get your lawyer involved at the commitment letter phase. Reach out to them then, send them here's the commitment letter that we're considering. Like any contract you might enter, don't sign it until you've gone to your counsel, counsel experienced hopefully with these matters, and let them give you some information, some guidance. One of the things I talk about there, you see on there, says collateral. You want to know the collateral for any loan that you're obtaining from the bank should be limited to the collateral should be the regular assessments and any special assessment that the board is going to adopt to either repay the loan or line of credit or to address the projects for which the loan or line of credit are being sought. That's generally speaking, and it shouldn't expand into insurance proceeds, and it certainly shouldn't hit, chattel or other items. That to me is documentation for a for-profit corporation that has inventory. Your collateral is basically on your assessments, and that's where it should be. And that's why it's important to address that at the commitment letter stage, so that we don't have to argue with them because once you've signed the commitment letter, you're agreeing to certain terms that they can then put in the loan documents. So to avoid having the back and forth and the challenge of negotiating your loan documents, the expense of having to do that as well, best to get the attorney involved at the commitment stage. It's at that stage, if not before, it's at that stage also where I will pull your documents and I'll review them to ascertain, hey, do you need a vote of the membership to borrow funds? Are you going to be doing a special assessment? Or are you going to do a line item in the budget to repay? I have some communities that are setting up. They have a 10-year loan and they are setting it up so that come January, it'll be a line item in the budget and it'll be a line item in the budget for the next 10 years. And that's completely acceptable rather than having to do a special assessment. These are things you'll discuss. These are business decisions, business terms. But in order for you to know these things, you want to get the commitment letter over to your counsel, let them review it, let them get with you and go over these things and with you and your business advisor. But that's when I look to see, do you need a member vote? Because if you need a member vote, you want to know that. I will tell you, the bank will ask, who's your counsel? And so I've had clients say, Mike Bender, K Bender MM. So the bank counsel will email me the loan documents. Here's drafted loan documents. And that's the first I'm hearing that there's a loan. So I haven't seen the letter of commitment. So there's some challenges there. But also I get the loan documents and they're like, the board wants to close on Friday and it's now Tuesday. Okay, that's not a very nice thing to do to me anyway. But even if I could, I could turn, if I had to in an emergency turn something around, of course I can. The problem is I pull the governing documents and right away I see, you need a vote of the membership to approve borrowing. Did you get that? No, we didn't. Okay, well, you're not closing on Friday because you're going to need a minimum of 14-day notice of a member meeting to approve your borrowing. So, but if you sent me that commitment letter, we're getting all this in place up front. We know what meetings you need. I can help, you can get help with drafting. I recommend you get help with drafting the notices and even motion language, especially when the attorney has to do an opinion of counsel. Because this way, if the attorney drafts the motion language, and I can speak for myself, I'll draft language that says, this is what according to the loan documents, this is what I need you to approve in your motion so that when I sign the opinion of counsel saying that you've done everything properly, I can sign saying you've done everything properly. I've gotten, sometimes I'll have minutes sent over to me and they're insufficient in accordance with the loan documents and your governing documents. And so I write back and I say, listen, we're going to have to call another meeting. And it could be a 48-hour notice if it's just to approve the loan. But if it has to do with a special assessment, it's going to be a minimum 14 days. So again, all of these things can be addressed at the commitment letter stage. So I can't emphasize enough. Consider getting with your counsel at the commitment letter stage before you sign it, and then get the process going forward. Again, if you have experienced counsel, they can walk you through all that, and your management team will be very happy about it as well, because it takes a lot of the burden off of them. Your typical loan documents are going to be your security instruments, your collateral assignment, which is what I talked about. It's a collateral assignment of lien rights. It's basically you, the association, saying to the bank that if we don't make the payments to you on a monthly basis, you have the right, we're going to assign our lien rights that we have to each owner to you, and you have the right to go back to each owner and say to the owner, hey, your next month maintenance payment, you need to pay me, pay to the bank. Okay. It is not going to be, it's unlike a construction, project where you have a notice of commencement that's recorded against the building. And if someone goes to sell or refinance, then that shows up on a title search. This is not going to impede sales or financing. This is basically, but it is a collateral assignment. There'll be a loan and security agreement, the promissory note, and then the UCC one, which is a financing statement that does get recorded. And it's basically just securing the bank's interest in the collateral, which, as I mentioned, should be limited to the assessments. Okay. The closing costs, you're going to be responsible for paying the bank's commitment, paying a commitment fee to the bank, and for bank counsel fees. Know that the bank's counsel is going to have fees for preparing the loan documents. They vary depending on my experience, they typically depend on the amount of the loan, but they vary, but you will have that obligation. You'll be responsible for recording and document stamps. And of course, you'll be responsible to pay your own association attorney to do the proper process and protect the association accordingly. And if a borrower's counsel, if an opinion of counsel from association counsel is required, certainly that's something that what they're doing there, the bank is basically saying to the law firm, we need an opinion from you in order to close this loan. And your opinion is what we're relying on, that everything's been done properly. So if down the road something wasn't done properly, the bank's going to look to me and say, hey, wait, we have this opinion that you said everything was done properly, which is why the firm is taking on that liability, and there is a cost to the association for that. And I will assure you that in order to sign that opinion of counsel, I'm going to have T's double crossed, I's double dotted. And that's why at the commitment letter stage, I can go through all that with my client, the management team, and avoid surprises. It makes the process much smoother. And that's why I recommend whichever counsel you work with to go reach out to them at the commitment letter stage. Okay, let's quickly go into funding. The funding of the loan. Okay, we talked briefly, I talked about options for repayment of the loan. The special assessment route is often used. There's two ways. You can use a line item in the budget, as it says there, or you can amend your budget. And what that means is if you're borrowing, at some point mid-year, and you want to add you don't want to wait until the new budget to add a line item, you could do an amended budget, and that process would follow the same way you approved your original budget, where you'd send out a 14-day notice to the membership, would be mailed along with a copy of the proposed amended budget. And that's going to, and then even 720 doesn't require you send out the proposed budget, but I think in my experience, most communities do, or many do, but it's not mandated by 720, but in 718 it is. The board would meet, it would approve the amended budget, and then it would notify the owners going, hey, next month, the new dollar amount for assessments is this. And that increase would be the line item you've now added for the repayment of the loan or the line of credit. And let me just also back up with a line of credit, by the way, what happens with a line of credit is typically, like I said, you'll have a period of time, 12 months is standard. I like it when they give the board, the association, the opportunity to maybe do another 12 months upon proper notice, and it's interest only payments. And then as the line of credit period closes, whatever funds you've borrowed is converted to a term loan. And that's when your monthly principal and interest is set up and goes forward. So that during the line of credit financing part, you're paying interest only and only on the money you've taken out. So if you get this line of credit and for the first 6 months, you don't draw a dime, you don't have a payment to the bank, or you shouldn't. You're only paying money to the bank once you start drawing money, and then it's interest only until that period ends. And so all of those things are be considered when you're negotiating terms with the bank and when you're looking at what's best for your community. But repaying the loan, like I said, line item in the budget or the special assessment, and really it is a business decision. Some communities I have decided they want to go line item in the budget, but they do want the option if they need to adopt a special assessment, and I'm okay with that. But it is required to be within a proper motion, and again, which I would recommend you allow council to help draft, and the board approves it, and then the bank gets a copy of those minutes, so they're approving them as well before the loan can close. With the special assessment, and I'm going to be very general here because these are going to be case by case approaches. I briefly touched on it before. Options for repayment. The special assessment for repayment of the loan, in my opinion, should provide options. You should provide a lump sum option, which would allow owners who want to just pay all of it up front and not have to pay any interest the opportunity to do so. And then you'll have the other options. Typically, what I have, if it's a 5-year loan, you might have 60 equal payments that are due monthly by the first of the month. I will tell you this: and here if you've heard nothing else, hear this: if you are adopting a special assessment for repayment of the loan, the way you adopt that motion is important. You want to make sure that the language does clarify that if it's a special assessment, due monthly, as opposed to a large special assessment that you're allowing owners to pay in installments. You want it to be due monthly, and that's that line item with issues with lender foreclosure, because that's where it could come in. Say you have a 5-year special assessment, and somewhere along the line, one of the owners has a bank that forecloses on the unit. Well, that bank is going to claim that entire special assessment is wiped out. We want to be able to counter that by saying, no, the language in the statute says that any assessment that came due prior to the bank taking title. So that's why it's important that you have the special assessments are due on the first of each month from January 1st, 2021 to December 1st, 2026, or whatever it is. They're not this way. The bank foreclosed in 2023. All those other monthly assessments have not yet come due. So be careful with that. Again, why you want to use experienced counsel when you're doing these things, and why you want to make sure you get with counsel and have these language work with them. Even if you draft it yourself, have it run by counsel to get it approved. It's not an area to try to scrimp and save a few dollars, guys. It's worth spending a few extra bucks to make sure these things are done properly. The bottom line is when you're borrowing these funds, you're borrowing probably 6 figures, 7 figures. So add another 5,000 or so to the bottom line. And that should, typically that's more than enough to cover any, assistance you need from legal counsel. At least I can speak for myself. It should be more than enough. So that's with options for repayment and how I'd recommend going about it, and what the issues with lender foreclosure means, the need to have the proper meeting notices, meeting minutes that spell the same. We've talked about all that. Some other things to consider: prepayment penalties and amortization. When you approve that's all part of the letter of commitment. You'd like to make sure you have no prepayment penalties at all. Certainly you should have no prepayment penalties if you're prepaying by way of collecting funds from the membership. Many banks, though, will have a prepayment penalty if you're going to pay them off by refinancing with another lender. But if you're refinancing with that same lender, in my opinion, you shouldn't have to pay that lender a prepayment penalty. I've seen that come up too. So it's something I think you should be challenging the banks at the negotiation stage, because once you've signed that letter of commitment, you're done. At least on that point, it's going to be very unlikely you'll get out of it without losing money. If you wanted to walk away, you'd lose the commitment that you gave them. Amortization schedules, that is another one. The ability for you to go to the bank maybe once or twice a year at most, and I think should be without charge, to re-amortize the loan. If in fact, say you have an owner after a couple of years says, hey, I'm moving and I'm going to pay off the rest of my special assessment, so you get a big lump sum of money. You want to be able to turn that around, give that to the bank, and have the bank then re-amortize, which would lower your monthly payment accordingly. So that's in general what that means. The specifics would be discussed with your management team, with your accountant, with your lawyer as needed. But those are important things to also keep in mind when you are at the letter of commitment stage and when you're considering your terms for the letter of commitment and moving forward. Let's see. I think we've done a pretty good job of hitting on a lot of items. I know it's a lot of material. I was specific where I could be. There's a lot of general stuff, but in overall, I think you guys, I hope, got a good idea of the process and really how to go about doing this correctly. I'm going to take a look now. Jess, did you have anything you wanted to add before I go to the questions?
No, you've been very, very thorough, and I learned quite a lot. Thank you so much. So yeah, let's take the last few minutes here to see if we can get some questions answered. And again, we do keep record of all these questions, so we'll filter through them and we will follow up. And if you have anything additional, you can just email info@castlegroup.com, and we'll be more than happy to get back to you. So go ahead, Mike.
Okay. Annie asked line item reserves, same for HOAs. Yeah, Annie, I think it's not same statutorily, but I think if you're going to do statutory reserves for an HOA, it's not going to be the roof, painting, paving, because HOAs don't necessarily all have those responsibilities. But if you're going to adopt, if the governing documents or the membership approves line item reserves, they become statutory, and then you need to then be doing the same process I talked about, where the board should be fully funding them unless they get the membership to waive or partially fund, and you shouldn't be using funds for a different purpose. Okay, Robert. Robert, I will be honest with you, Robert, I am not familiar with the Florida minimum required reserves, so I cannot comment on that. Yeah. I think any good lawyer should be able to say that. I'm just not, it's something I can look into, but I'm not familiar that there is I'm not aware of any minimum reserve requirement in the state of Florida. As far as statutory, I mean, other than the fact, other than what you are required, what your reserve studies perhaps indicate. Okay, Rick, our condo association documents do not specifically cover special assessments, just regular assessments covering operating reserves. Does the board need approval to assess a special assessment to cover an item such as painting? Okay, Rick, again, and guys, and forgive me, obviously I'm answering the questions the way you're posing them. So this again is informational, it is not legal guidance. Specifically, you should be going to your legal counsel and getting getting written guidance on some of these items. But in general, Rick, what I'm saying is if it's painting is considered necessary maintenance, in my opinion. So if you have to paint the building, then that is a necessary maintenance item. The board would not need approval of the membership. If you're considering changing a paint color or any other possible material alteration, then you need to look at your governing documents to determine whether you need a vote of the membership. And you should definitely be communicating with counsel on that. Matthew, hey, Matt, if an HOA has statutory reserves, can they also create pool reserves going forward by adopting a resolution? Well, Matt, I guess I really want that's honestly, that's going to be document specific. I'd like to see what what you talk about with statutory reserves and can they create pooled reserves? And I know you say pooled, but I don't think you mean pooled. If they already have statutory reserves, I mean, I'm not sure they have to create anything. If you're saying they have line item and they want to go to pooled reserves, then I think the statutory, if they're statutory, then I think the limitations for an HOA are the same as condo, where if you're going to take funds that have been properly reserved in line items and put them into a pool, you need a vote of the membership. Jill, I believe you are. I believe a reserve study would be part of the official records open to inspection. Jill asked if the owners are entitled to get a copy of reserve study. Thank you, Armando. In a condominium, if you had Jackie, you had a vote to change to pooled reserves, then you can move things around, right? Is that decision continues in the future? Does it need to be redone annually? No, once there's a proper vote to have you pool your reserves, you don't need a vote again. You do not need a vote again. You're funding the reserves into a pool, and so long as you're talking about if you want to use those funds though for an item that's not within the pool, then you're going to need a vote of the membership. But if it's within the pool, you will not, Jackie. Betsy, can the association get a bank loan for a re-roofing project without having a special assessment in place? Yes. As I mentioned, you can borrow funds by way of, well, actually, I see some of these questions were done before I did the program. So yes, Jackie, where'd you go? Did you just close that one out?
No, I don't think so.
Where
It's
did
right
it go?
here. In a COA, if you had a vote to change full reserves.
No, I
and you
did that
can-
one. I'm sorry.
With that one?
Betsy, I'm sorry, Betsy.
Betsy, yeah.
Yes, you can. You can do a line item in the budget, as we talked about. Armando, is a condo association recently voted for partial funded reserves? Would that report be sufficient as assessment report? Armando, I'm sorry, I don't understand the question. Constantine, operating surplus would be, and this is something you absolutely should speak to your CPA about, as well as your management team. But yeah, operating surplus is, you have you budget for operating. Say you budget $100,000 because that's what you reasonably believed you need, and you don't want to be shoestring. You want to have a little bit of play in there, but you reasonably believe, and at the end of the year, you did such a great job with certain projects and certain things that you only needed 80,000. So now you have this operating surplus from that year of $20,000. That's essentially what an operating surplus is. How you address those funds with regard to where they get applied to avoid tax obligations, things of that nature, get with your CPA. Heidi asks, special assessment. If there are 3 line items, does the amount need to be shown for each one or just a grand total? Heidi, that's a good question. I think if you have line items and you have a reasonable estimate, if not on the notice, I think it's helpful to spell them out. I think legally you can do if you could say, hey, we're doing roof painting, paving, and the total special assessment is going to be $1 million. I think legally that is appropriate, but I think that the more appropriate way, in the interest of full disclosure, in the interest of transparency, is to be able to break out those line items. Because obviously, if it's $1 million, somewhere along the line what those $3 amounts were to get to the million. So my recommendation would be to break it up, although I don't know that it's needed. Our board does not look at special projects from reserves, just spends as needed without notification. Okay, Jill, that's just, Jill, I'm sorry to hear that. Let me see. Spend 200K on last year. Again, I don't know if your HOA has statutory reserves. That may be a reserve situation that's more discretionary, and removal and replacement of trees and landscaping, which is typically within the discretion of the board if they have to address that, would be a good example of when we have quote unquote reserves in an HOA, which aren't statutory, they're more discretionary, and the board has using them for a proper purpose without the need for membership vote. That said, Jill, that's very fact specific, and it would require further looking into it. Hi, Joan. I'm not sure you're saying bylaws say in event of emergency a special assessment. I'm not sure what that is replying to, but you can follow with me later on. Joan is someone that we work with. Christine, roof replacement's the same as roof maintenance. So if our documents allow roof maintenance by the HOA and to split that among. Well, I don't know. Again, it's Christine, the question that you raised, I don't know if this is, I think if this is what you meant to raise, but the question that you raised is, roof maintenance, is that the same as roof replacement? And there has been debate whether maintenance includes replacement. And I recently have been recently learned that there is actually even a case, I believe, that references the fact that maintenance would include replacement. But that said, I think that there is a distinction here. I think that you might have a line item in your operating budget for maintenance of the roof. Because like, for instance, if you have a warranty on your roof, then annually you're supposed to have maintenance done, and you may have a line item in there for roof maintenance to keep your warranty in place. And that would be different from roof replacement. So again, I think we need to be more fact specific, but I hope that offers a little bit of clarity. Yeah, Joan, okay, Joan, bylaws say in event of emergency repair, a special assessment must be voted on by a majority of owners. And that would be an example, Joan, if it's truly an emergency repair, if it's truly a repair, versus a material alteration, then that particular language would not be can be superseded, but will be superseded by the current case law that says the board not only has the right but the obligation to undertake what you're calling an emergency repair.
So Michael, we're running out of time. So do you want to maybe?
I think I only have
last question.
Yeah, I think I only had two left. I think I got my last two, which is just, wait, are there more coming here? Well, I answered
There's
this
about
one for,
15.
I already answered that one live for Constantine. I answered what collateral is. Again, there is no, you're not mortgaging any asset of the condo. It's just the assessments. Mary, hey, Mary, what point must potential buyers be informed an assessment of borrowing funds are being considered? Well, by law, Mary, until the board's actually approved it, the association has no obligation to inform. But again, when the member, I do recommend the board be communicating with owners along and keeping them informed. And then then that's between the seller and the buyer. Stephen wants to know, do we start with an attorney to help reach out to a lender? Stephen, what I can offer you there is, I tell my clients if they're looking to do borrowing, I can certainly, like with any with any vendor, you can certainly ask your attorney to give references, and I'm happy to give out references to banks that I know do community association loans and seem to do a good job and make the process as more simple and less challenging for everybody concerned. Maria, 20-year assessments are not common in my world, but I have seen assessments that have been as long as 15 years or so, but an assessment can be any length of time, but that's a very, very long time. All right, last thing I'm going to answer. Okay, Jane, borrowing. Jane, that's a detailed one that's going to require a little bit more. And so I'd ask that you follow up with association counsel on that question because it looks like a good one. But Therese, you wanted me to review what was said regarding special assessment due on the 1st of the month. And I'm just going to say that what I said specifically, it's very important that you, the wording of the motion for the approval of the special assessment be specific. And that's why I recommend you get with experienced counsel to work on that language to ensure that the motion language that you have in place will protect the association, in particular in the event of a lender foreclosure during the term period that the special assessment is being repaid, as well as address how to handle the payment of the future, any unpaid special assessments if there's a sale of the unit.
Okay.
Guys, so I am getting played off the stage as they will. I know Jeff and Jessica just going to give you guys a little bit of follow up about the surveys and stuff. So please listen carefully to them. I do want to thank everybody. I hope you got some great information out of this. For those of you who are around next Wednesday at Broward at the Signature Grand, CAI is going to be having their expo. We'll have a booth there. We'll be teaching a class there as well. And there'll be a lot of other vendors and other classes. And we encourage everybody to come out, wear your masks, be safe.
Thank you so much, Michael. Really appreciate it. So there will be a link for you so that you could fill out a survey for us. And if you are a CAM, you will need to fill that out in order to receive credit for this class today. There will also be an email that's going to be sent out tomorrow as a follow-up with that link. So I think you have your bases covered to get your credit for this class today.
Appreciate that. I just want to mention one last thing. I know you need to go. Several people asked the question about the availability of the slides. On that evaluation link that Jessica just mentioned, there is a button at the top. Click on that button. You'll be able to view, download, and save the slides if you desire them. So once again, thanks. Great job to both of you.
Thank you, everybody. You have a wonderful afternoon.
Bye, all.
Bye. Thanks, Jess. Thanks, Castle.
Bye.
Bye-bye.
Bye-bye.